The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
Good morning. Would the court officer please call the case?
Good morning, Your Honor. Situation in Darfur, Sudan. In the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman, case reference ICC 0205-0120. And for the record, we are in open session.
Thank you, court officer. I am Judge Piotr Hofmański, presiding in this appeal arising from the case of the prosecutor against Ali Muhammad Ali Abd-Rahman. My fellow judges in this appeal are Judge Chile Boysuji, Judge Howard Morrison, Judge Luz de Carmen Ibanez Carranza, and Judge Solomi Balongi-Bosa. Due to COVID restrictions, the hearing is conducted on a virtual basis with myself and all parties and participants attending remotely via the Interactio system. The hearing is accessible for everyone via ICC website. May I ask the parties to introduce themselves for the record, please starting with the defense. Hello, Mrs. Brady. Are you accessible?
Ms. Brady, you have the floor.
Good morning, Your Honours, and good morning, everyone in this courtroom. My name is Helen Brady, and I'm the Senior Appeals Counsel in this case. I'm appearing today with Ms. Priya Narayan, Appeals Counsel. Thank you.
Thank you. And the defense, please. Mr. Lauchi, you have the floor.
Yes, I think there was a technical problem. So I represent the defense team, Cyril Lauchi, lead counsel, and Ahmad Elisa. And I was saying that Madame Venise, an assistant lawyer, couldn't be present today, given that it's the first time that we have this virtual case before the case. And I would like to say I'm very pleased to be a new member of the defense team. Thank you.
Merci.
Thank you.
Thank you very much. For the record, I note that Mr. Abd-Al-Rahman participates in the via Interactio from a remote location. Today, the appeals chamber will deliver its judgment in the appeal of Mr. Abd-Al-Rahman against the decision of the pretrial chamber 2 of 10 July 2020, entitled Decision on the Defense Request under Article 67(1)(f) of the Rome Statute. This is a non-authoritative summary of the appeals chamber's written judgment in the appeal. The latter will be notified after the hearing together with a separate concurring opinion by Judge Ibanez Carranza. I will now briefly outline the procedural history of this appeal. On 10th July 2020, the single judge on behalf of the pretrial chamber 2, I will refer to this as the pretrial chamber, rejected Mr. Abd-Al-Rahman's request for an order to registry to provide the defense team with the interpretation and translation services that are necessary for the preparation on the suspect's defense and for his communication with the defense team pursuant to Article 67(1)(f) of the statute. I will refer to this decision as the impugned decision. In the impugned decision, the pretrial chamber held that the right to interpretation and translation set out in Article 67(1)(f) of the statute is limited to the purpose of understanding proceedings and does not cover client-counsel communications. On 7th August 2020, the pretrial chamber granted Mr. Abd-Al-Rahman leave to appeal the impugned decision. On 13th August 2020, Mr. Abd-Al-Rahman filed his appeal against the impugned decision. At the outset, the appeal chamber notes that some of the arguments raised in Mr. Abd-Al-Rahman's appeal do not relate to the findings in the impugned decision and are thus dismissed in limine. Sorry. The essential argument that is addressed in the judgment is whether the pretrial chamber adopted an excessively limited definition of proceedings within the meaning of Article 67(1)(f) of the statute in excluding communication between the suspect and his or her counsel from its ambit. Mr. Abd-Al-Rahman contends that counsel is the main point of contact through whom the suspect is able to understand and follow the proceedings. He submits that the interpretation of the statute adopted by the pretrial chamber is incompatible with the right of every retained person to communicate fully where necessary with the assistance of an interpreter with his or her defense counsel or assistance to his or her defense counsel. Both the prosecutor and the registrar submit that the pretrial chamber's interpretation was correct. I shall now turn to the appeals chamber ruling on Mr. Abd-Al-Rahman appeal. The appeals chamber can find no error in the pretrial chamber's interpretation of the word proceedings in Article 67(1)(f) of the statute. This provision expressly limits the right to interpretation and translation to situations in which the proceedings of or documents presented in the court are not in the language which the accused fully understands and speaks. It does not relate to communication with defense counsel. This is consistent with the human rights jurisprudence concerning the corresponding provisions in human rights treaties. The appeals chamber therefore finds that the person with sufficient means to do so must pay for any interpretation services that may be necessary to facilitate communication with their legal team. In the case of persons who do not have sufficient means to pay for their legal assistance, an interpretation cost for the purpose of client-counsel communications must be considered within the scope of the legal assistance scheme. The appeals chamber considers that the fact that the suspect and his counsel do not speak the same language and cannot communicate without assistance clearly has the potential to impact on the rights enshrined in Article 67(1)(b) and (d) of the statute. Therefore, a solution must be found to allow communication to take place. The pretrial chamber found that it is the responsibility of counsel to use the legal aid funds to which the suspect is entitled to ensure that his or her client needs in terms of communication with the defense counsel are adequately satisfied. If Mr. Abd-Al-Rahman considers that such arrangements are inadequate to ensure an effective and efficient defense, the appropriate application for any additional assistance considered reasonably necessary must be made to the registrar in the first instance. The Appeals Chamber understands that Mr. Abd-Al-Rahman freely chose counsel with whom he cannot communicate. While this choice of counsel has been respected, it is for the pretrial chamber to ensure that this situation does not impact on the delivery of an effective and efficient defense on behalf of Mr. Abd-Al-Rahman. For these reasons, the Appeals Chamber finds it appropriate to confirm the impugned decision. Judge Ibanez Carranza appends to the judgment a partially dissenting opinion which sets out of her view on the need for a systemic, and comprehensive reading of defense rights. She considers that in the circumstance of the present case, Mr. Abd-Rahman has the right to avail of interpretation services in order to communicate with his defense counsel for the purposes of preparing his defense, but the exercise of this right might be modulated in the manner provided in the statute. This brings us to the end of the summary of the Appeals Chamber's judgment. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.